Bar on behalf of the appellant Peter Meersman, and I would like to reserve 5 minutes.
Five minutes, yes, sir.
So this case, this arises out of a trust, several trusts owned that Mr. Meersman was a beneficiary of, and really the only issue is the statute of limitations. That's what the case was dismissed on.
Or several statutes of limitations.
Several statutes of limitations, right. But ultimately, the question would be is which statutes of limitation apply, and when did the statute of limitations actually begin to run? Those are the two things. There were actually two trustees in this case. Started off with Regions being the trustee, and they resigned in 2011, after which Michael Castellarin was appointed by the court as a public trustee, and he remained on this case, on the trust, until the trust was dissolved by the court in 2015.
Counsel, you just mentioned that Regions resigned in 2011. I have in my notes that it was in October 2010 that they were granted leave to withdraw or resign.
That may be correct. I have to say I came in late on this case, and so.
So did I.
Okay. So I have read 2011 quite a bit, but it could be 2010. That does not change our position.
They resigned as trustee, but they remained in the handling the funds, not directing their use.
Right, right. There was a letter in the records where Mr. Castellarin sent a letter to Mr. Meersman stating that he understood Mr. Meersman was unhappy with Regions as being the trustee, but asked if he would keep them on to manage the funds. And they stayed on managing the funds past their resignation.
But what to expend and whether it would be income or principal corpus, decision was made by Mr. Castellarin.
That's my understanding, yes. And so they remained on until it was administratively dismissed in 2015. At that point, Mr. Meersman, acting pro se, filed a lawsuit, and the service was not correctly done. He added Mr. Castellarin on March 1st, 2016, when he was fully apprised of his role. During this time, he had various mental health issues going on, but he was still trying to do to the best of his ability to protect his rights.
And this is when he was pro se?
This was when he was pro se, right. There was an attorney that was involved, but that attorney never filed a lawsuit, and it was brought up, the court brought up, and the trial court brought up that things were turned over to his attorney. I was never able to even get anything from that particular attorney later, but that's neither here nor there.
Counsel, are there any substantive variances between the claims that are stated earlier in this litigation and the claims in the most recent round, other than perhaps the conspiracy claim? Are there any other substantive differences between those claims? And you note that he was suffering under disability. He put forward a number of claims. Is there any substantive difference in the new filings versus the earlier filings?
Well, the biggest substantive difference is the framing of for the 10-year statute of limitations, arguing for the ways and failure to act reasonably based on Regions no longer being a trustee but still being involved, and the conspiracy. Also, when he initially filed, Michael, in 2000, so I know you're talking about the latest, so there's several filings. There was the initial filing when Mr. Castellarin was not involved, then the 2016 filing, and then the most latest filing, it's mostly cleaned up. These were pro se filings, and when I came onto the case, very voluminous, a lot of filings, and hard to follow pro se filing that when I came onto the case. And so I could understand how the trial court might misunderstand or misinterpret some things. In fact, even on oral arguments, When I actually pointed out to the trial judge, trial judge that they were on past 2000, all the way up to 2015, that Regions was still involved. She didn't realize that, and there was some confusion. I was able to point to the record. So I think by the way it was styled, there was just, things were not laid out structurally in a way that was easy to follow for him to be able to get his due process.
In the context of the statute of limitations, you are relying upon incapacity to toll the running.
That's one of
What
yes.
evidence is in the record that your client was incapacitated, and when did that exist, or when did it end?
There was affidavits in the record, and we also put in, there was a letter from his doctor that we brought in later during one of the motions for reconsideration. But even before that, there were affidavits in there from his wife and his mother-in-law. And there's also in the record correspondence from Mr. Castellarin about payments to a psychologist. That's in the record as well. So there was evidence that was showing that even Mr. Castellarin knew there was some incapacity going on.
Well, a lot of people see a psychologist that aren't mentally incapacitated. So to what extent did the psychologist or doctor state that his mental capacities were limited?
He definitely was, from the affidavits, not from the so the last letter was not allowed in by the trial court, but the affidavits from his mother-in-law and his fiance were saying that he was unable to even sometimes get up, unable to even focus for a long period of time. So that's the record that we have.
All right, thank you.
All right. In one of the footnotes in one of Chancellor Martin's rulings, she said, giving Peter the most expansive view possible, the statute of limitations should start to run from March 1st, 2016, and that's based on that's when he should have known certainly that Mr. Castellarin was involved in the conspiracy. And so even if we just go with, not even with the 10-year statute of limitations, but with the 6-year statute of limitations for contract, that takes you to 2022, which means there was only one use of the staving statute. We believe also, though, that the 10-year statute should at least apply to Regions based on our interpretation of the Myers case, which in that case, there was a trustee that resigned as a trustee but continued managing the trust, and there was no successor trustee. And so because of that, the court in Myers said, well, we're still going to consider you a trustee. In this case, there was a successor trustee, and so because of that, Regions would not be considered a trustee for anything that happened after that. And so that's why we don't believe that they should fall under the 3-year statute of limitations. Also, I couldn't find case law one way or another to say definitively if a public trustee fell under the 3-year statute of limitations or the 10-year statute of limitations. We believe, though, that because of the nature that this was someone appointed by the court, that it should fall under the 10-year statute of limitations for public officers. I did not see the other side put in a case on that one way or another. Also, we're also relying on the Regions versus the Kramer versus Regions case to say that because of the nature of this being immediate unconditional under the payment being due immediate unconditional under the second restatement of trust, that this also falls outside of the Uniform Trust Code. So for those reasons, we believe that the statute of limitations should have been brought forward. We also believe that we should have been allowed to amend. I was told by the chancellor that they would consider my oral motion to amend. She said it was time barred, but simple math, if you go from even 2015 and add 10 years, that's 2025. So it should not have been considered time barred, and she should have at least done an analysis to see whether or not it applied.
All right. Thank you, Mr. Drake. We'll hear from you again on rebuttal. Good morning, Ms. Helton.
Good morning, Your Honors. We're going to be evenly dividing our time with Mr. Castellan's counsel this morning.
All right. Have you told the clerk how much time, or do you want to tell me?
7 minutes, 30 seconds each.
All right. Thank you. All right.
Thank you. My name is Lisa Helton. I represent Regions Bank and the 4 individual employees who were sued by Mr. Meersman. I want to address a few points that were just made. To the question of resignation, there was a resignation lawsuit. Regions was allowed to resign in October of 2010, but that became effective upon a new trustee coming in. Mr. Castellan came in February of 2011. I also want to address, we are here today on Mr. Meersman's operative complaint, which is the original complaint he filed. I realize that Mr. Meersman, after the case was dismissed against Regions, asked for permission to file an amended complaint. That motion was denied, but the 4 corners of Mr. Meersman's complaint are grounded in claims involving Regions' administration of the trust in the 90s and through its resignation in 2011. There's nothing fleshed out about Regions staying on. There's nothing fleshed out about Regions serving as asset manager or any details or any claims about Regions serving in that role. So all of that is in the amended complaint, which was, again, after the case was dismissed. It was not allowed to be filed. So if we're just sticking with the 4 corners of Mr. Meersman's complaint, this is a breach of trust case. That's what we have here. He is unhappy with the way in which Regions administered his trust as trustee in the 90s and the early 2000s. The resignation lawsuit was before the probate court in Davidson County. Mr. Meersman was represented by counsel. Before Regions resigned, it produced full and complete accounting statements dating back to the early 90s, and those statements covered every single encroachment that it ever made for Mr. Meersman on his behalf. All of that was produced to him in 2010 before Regions resigned.
Now, Regions followed First American Bank as trustee. Is that correct?
I believe that's right, Your Honor.
And while First American was in office, they filed a petition with the court to interpret the trust as to how they could distribute the funds to or for the beneficiary's benefit, and the court put down what I would classify as a clear order. Is there any allegation that Morgan Keegan failed to follow that order?
Well, I believe the order allowed for encroachments even to exhaustion, going by memory. So what I understand Mr. Meersman is upset with is he wanted the trust to last longer, but at the same time he wanted these encroachments. And so he asked for and received encroachments, and then the trust terminated pursuant to court order in 2015, and he's upset that
because there wasn't enough money left to justify the management. But there's no question that the money went for the benefit of the beneficiary, but some of the distributions in question are that the bank distributed money to renovate a house and to buy a house for the beneficiary, and then there were promissory notes, and that's a little unusual in my understanding. What do you say about that?
Well, I mean, at the stage of this case, we were really looking towards the statute of limitations. So
that's true.
We haven't gotten into the merits.
Yeah,
but
I apologize. You're absolutely right. I got off focus. I'll let you go back to the statute of limitations.
Thank you, Your Honor.
Counsel, with regard to the statute of limitations, footnote 10 we've got the language, right? Plaintiff's counsel made an oral motion to amend the hearing. However, since the claims are time barred, any such amendment would be futile. Do we know why a conspiracy claim would be futile in terms of the statute of limitations from the trial court's ruling in this case? Do we have clarity as to what the rationale is for that futility?
My understanding is, again, going to the four corners of the operative contract, or the operative complaint, Mr. Meersman is upset about the way that Regions administered his trust. We believed that conspiracy was not a standalone cause of action, but really you look to the gravamen. And so when we were analyzing this, we said—
Has the trial court told us that, though? I mean, we've got this discussion that goes on in the hearing about conspiracy. There's an attempting to bring conspiracy into it, and it's at a later stage. And the trial court essentially seems to take the view that, well, if it matters, then we'll consider this further, but it doesn't matter. But I'm wondering, do we know why it doesn't matter? I mean, you've made the argument, right, that it's tied to the shorter statute of limitations time period, and that may be a correct argument. But do we know from the trial court's ruling why the trial court didn't think that the 10-year statute of limitations, or that opposing counsel is proposing, was applicable?
Well, the 10-year statute of limitations applies specifically to executors and other categories of persons. It does not apply to trustees in A.
None of that's stated, though, in the trial court's ruling, though, right? I mean, essentially with regard to the conspiracy issue, all we really have from the trial court is that language that the claims are time barred, but not really an explanation on the conspiracy ground or potential ground.
Well, I think for purposes of Regions, when we moved for dismissal, we were moving to dismiss the original complaint, and the only discussion of conspiracy was relating to when Regions served as trustees. So for Regions purposes, we never got into a discussion of the trial court about the 10-year statute of limitations or any sort of conspiracy for times when Mr. Castellarin was trustee, because we moved to dismiss the original complaint. And
So under your view, even if it is 10 years, even if opposing counsel's right, Regions is still out in terms of the 10-year time period?
Because the 10-year statute doesn't, by its terms, apply to trustees, and then the Part C of it is just a catch-all. I mean, in our world, there's a trust code that gives 1 year. When you receive a report from the trustee, you have 1 year to sue. And that statute was in place back in 2010 when Mr. Meersman received the full and complete financial picture of Regions administration. Then there's a 3-year statute of repose. And so when we moved to dismiss, we said 1 year from 2010, okay. If you're not satisfied by the 1 year, there's a 3-year statute of repose in the trust code from Regions' resignation in February 2011. That runs to 2014. Statutes of repose are not told by periods of incapacity. So the first lawsuit against Regions is 2015. That was stale.
I mean, is it fair to say the upshot of the argument then is that looking at the gravamen of the original complaint, you first had to determine something a claim that would fall outside the trust code in some way before you get to any of this other, once you can identify a claim outside the trust code, then you would worry potentially about whether you got caught by the 10-year catch-all provision. But until you could do that, you're stuck with the 3-year period in the trust code.
Exactly. And again, what he's upset about, he is upset about these encroachments. And he was fully informed of those as of 2010. And beyond that, it's just becoming more and more creative. Like, there's 14 causes of action filed in the 2023 complaint, but this is a trust case. Like, if we were looking at the operative complaint, and just for the exercise, we said, okay, what's the longest? of the four corners of this complaint, what's the longest statute of limitations? He alleged breach of contract. That's a 6-year statute of limitations. He was fully informed of the full and complete financial picture as of 2010. So that takes you to 2016. But again, what contract? This is not a contract case. There's no contract attached to the complaint. This is a trust case.
All right, thank you, Ms. Helton.
Thank you so much.
Good morning,
Good morning, Your Honors.
Ms. Murphy.
May it please the court, my name is Ann Murphy. I represent the appellee, Michael Castellarin. I want to address the last question regarding the conspiracy argument first. In the record, volume 7, page 1010 and page 1067, the court does address the conspiracy claim, and it does dismiss it based on, first, that it's not a standalone cause of action and that all the other claims were dismissed. But second, because the 3-year statute of limitations for personal property would apply. And so the court did address the conspiracy claim in the statute of limitations regarding that. This court should affirm the trial court in all respects for 4 reasons. First, all of Mr. Meersman's claims are barred by the 3-year statute of repose for actions against trustees. Second, Mr. Meersman never alleged a breach of contract claim against Mr. Castellarin. But even if he did, it was untimely and not saved by the saving statutes. Third, the 10-year catch-all statute of limitations codified at Tennessee Code Annotated section 283-109 does not apply to Mr. Meersman's claims. And fourth, public policy favors affirming the trial court's rulings. All of Mr. Meersman's claims are barred by the 3-year statute of repose, which is codified at section 3515-1005C. And under Tennessee law, the gravamen of the action, the gravamen of the complaint, that is, the injury for which the damages are sought, determines the applicable statute of limitations. A court is not bound by the title of the pleading, but rather the court is to give effect to the relief sought in the substance of the pleading. Here, the gravamen of Mr. Meersman's complaint is a breach of trust. He asserts claims against Mr. Castellarin in his capacity as a trustee regarding the administration of the trust. A violation of a trustee of any duty the trustee owes to a beneficiary is a breach of trust. The Tennessee Uniform Trust Code governs proceedings against a trustee, and the trust code has a 3-year statute of repose, which is not told for incapacity. As you know, the statute of repose is only told by statute, and this statute does not contain any exception for mental capacity or concealment or anything of that nature. And here, the trusts were terminated on September 18th of 2015. So the 3-year statute of repose would have expired on September 18th of 2018. While Mr. Meersman did file his original complaint in 2015, the lawsuit was dismissed, this court affirmed the dismissal, and the Tennessee Supreme Court denied permission to appeal in February of 2019. Importantly, Mr. Meersman then failed to refile his lawsuit within the 1-year saving statute timeframe. This is where the saga should end. Mr. Meersman's cause of action was barred by the 3-year statute of repose, which ran on September 18th of 2018, excuse me. But Mr. Meersman went on to file 3 more lawsuits, starting in February of 2020, asserting nearly identical causes of action. And now Mr. Meersman has narrowed his issue on appeal as to Mr. Castellarin, asserting that only the breach of contract claim was saved by the saving statute, which is section 28-1-115, following the voluntary non-suit of his 2022 circuit case. And he's arguing that the 6-year statute of limitations for breach of contract would apply and that it wouldn't have run until March 1st of 2022. But Mr. Meersman's arguments fail for 3 reasons. First, Mr. Meersman never asserted a breach of contract claim in any of the 4 lawsuits. The operative complaint does not allege the existence of any contract between Mr. Meersman and Mr. Castellarin. As you know, in order to be saved by the saving statute, a claim must have been timely filed. It goes without saying that if a claim has never been asserted, there's nothing to save. It can't be saved. Second, the statute of limitations for breach of contract is 6 years from the date of the breach, or when a party demonstrates a clear intention not to be bound by the 6 years, bound by the contract. And 6 years from the termination of the trust, which is when if there was even a contract, when it would have begun to run, is September 18th of 2021. So even if Mr. Meersman had asserted a claim for breach of contract in the 2022 circuit case, which he did not, it would be untimely. And third, as I've previously explained, the gravamen of a breach of contract claim against a trustee by a beneficiary for issues with administration of the trust sounds in breach of trust, and it's governed by the Tennessee Trust Code and subject to the 3-year statute of repose. Next, the 10-year catch-all statute of limitations codified at 28.3.109 is inapplicable to Mr. Meersman's claims because, again, the claims asserted by a beneficiary against a trustee are governed by the Trust Code, which expressly provides a 1-year statute of limitations and a 3-year statute of repose. And Mr. Meersman relies on Wood v. Lowry for his argument regarding the 10-year catch-all. However, Wood v. Lowry is inapplicable and distinguishable from the case at hand because it concerned claims against an executrix for the mismanagement of estate funds. The 10-year catch-all expressly provides for actions against executors. It does not apply to trustees. We don't need a case law to tell us this because we look at the plain language of the statutes. In Woods, the claim against the trustee was dismissed prior to the appeal pursuant to an order granting summary judgment. Thus, in Wood, the Tennessee Uniform Trust Code was not even considered and it did not apply in that analysis. Instead, the court was analyzing whether the 3-year statute of limitations for injuries to personal property or the 10-year catch-all applied, neither of which are applicable in this case. Accordingly, the statute of limitations for 10 years does not apply. Finally, public policy favors the trial court's dismissal of the complaint. To hold otherwise would run afoul of the intent of the Tennessee legislature by carving out a new exception for public trustees only, creating a 10-year statute of limitations for public trustees and a 3-year statute of repose for just private trustees.
What is the distinction between a public and a private trustee?
A public trustee is appointed by the court, Your Honor. And it would totally undermine the purpose of the Uniform Trust Code, which is to provide some ultimate repose for actions against the trustee within 3 years after termination of the trust. In conclusion, Your Honor, the trial court should be affirmed in all respects.
All right. The beneficiary, the plaintiff, filed multiple amended complaints. Ms. Helton says only the original complaint applies to the bank. Which complaints apply to Mr. Castelleran?
I agree with Ms. Helton's analysis that for purposes of this appeal, I'm out of time, Your Honor.
You can please continue.
Okay. It is the operative complaint, not the amended complaint. The lawsuit was dismissed. The amendment was not allowed, so we're looking at the 4 corners of the original complaint in the 2023 case.
Okay, and I must have missed this, and Ms. Helton said the same thing you did, that the complaint was dismissed. But if the complaint was dismissed, how did he file amended complaints?
He filed motion for leave to amend following the dismissal and a motion to alter or amend the judgment.
And they were granted?
They were denied.
So the amended complaints are not
That's correct,
all
Your Honor.
viable. Okay, very good. Thank you.
Thank you.
Any other questions? All right, thank you. Mr. Drake? Do you agree that the amended complaints that are in the file are not properly before us because the court denied leave to amend?
I disagree, Your Honor.
Okay.
The reason I disagree is when I was first on the case, I made an oral motion to amend, and Chancellor Martin said she would consider it. She didn't. Normally, in cases like that, I'm used to judges saying you have so many days to amend. She didn't say that, so I diligently started working on an amended complaint, and a motion to amend, and then the day that I was filing my motion to amend in the amended complaint, she filed her order dismissing Castelleran. I think it was like 14 days or so. It was a very short period. And then in her footnote, she said that the reason that she did not allow the amendment was because it was time barred. And just on the face of that footnote does not make sense. If you go from 2015, and I think it really should be 2016, but they keep trying to go back to 2015. You go from 2015 and you add 10 years, that puts you at 2025. That's where we are now.
All right, but before we get to that, I'm still focused on the amended complaint. What I hear from Ms. Hilton and Ms. Murphy and you is that you tendered an amended complaint, but the court never put down an order granting leave
That's correct.
to file.
That's correct. That's correct.
Thank you very much.
Okay. As far as the contract, the claim, there was a contract because the trust under Will had contractual terms saying that he should get installment payments when he turns 60 and he turns 65. And we did put case law in there that said when there's an installment contract, each missed installment is a new statute of limitations. And so that's why we think that it should be considered. And also the federal case that he filed, while it did not have breach of contract in the caption, in the body of the complaint, it did talk about breach of contract, and you can see that in the record. Again, he was pro se, so he didn't write everything out correctly. And I even think I said there was no breach of contract in one time in oral arguments in the trial court, but I realized later that was incorrect. There actually was breach of contract in the federal case. And so for these reasons, Your Honor, and under Rule 54, as long as the case is not completely dismissed, the trial court still has full jurisdiction over everyone. And so when Regions was dismissed, the trial court still had jurisdiction. And I made the oral motion to amend before the dismissal of Castellarin, and I put in my actual amended complaint, a motion to amend the same day that Regions was put in. So I believe that both Regions and that the amended complaint should be considered, because part of our issue on appeal was the fact that the amendment was denied, and we believe that that was improper. We believe that it was not futile based on.
But the way you framed your issue on appeal is that the court erred in not granting you sufficient time to amend, which to me is a different issue than whether or not there was error in the actual denial of the amendment. I mean, how is that the same thing? Time versus the denial of the amendment.
Well, they are different things, but I believe I also talked about the fact that she said that it was futile and it was not futile. I definitely argued that it was not futile. And that was the only reason that she put in was the futility based on it being time barred, and it was not time barred. And that's all of my redirection.
All right. Thank you, Mr. Drake, Ms. Helton, Ms. Murphy, for your arguments. We'll take this matter under advisement.